suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Here he comes. He's holstered his guns, but he's here with you anyway. Good morning, Facebook. Welcome to your Talkback Legal session with Mr. David Whiting. Thanks for streaming us on ABC Radio Melbourne's Facebook page. And David Whiting, thank you for coming in again.
Oh, it's a pleasure.
Nice to have you there in the naughty corner. You know the number, 1300 222 774. Any legal queries, problems, David Whiting will do his absolute best to help you. Homework from last week.
2. We had John from Calista, and John's daughter had been walking in a rural street, presumably in the Shire of Yarra Ranges.
Oh, yeah, zapped by the electric fence.
Yes, but the electric fence was on the outside of the standard fence, not on the inside. Now, normally they are a single strand of wire that runs through an insulator and is on the inside of the fence for the purpose of containing animals. And John wanted to know what law there is. Well, there's the Electricity Safety General Regulations, which say that if it's an electric fence other than for the containment of animals, then you need to comply with a particular standard. And if it's not, so if it's for the containment of animals, then there are the Prevention of Cruelty Animals regulations. Right. So there are regulations, and I would come along and say that if the wire, the live wire, is on the outside of the fence, then it's not for the containment of animals, and you need to comply with a particular standard, and failure to do so puts you in breach of the regulations and would render you liable to a fine.
So what should
So he
they
might
do?
report the matter to the council,
Yep.
Perhaps to the electricity regulator, and perhaps to reportable to the police. But I don't see it as a safety. It's quite the same issue.
Yep.
I'd probably start with the council.
Okay.
And the
then
second,
Vince.
Vince was in Burra. He has a tree that is interfering with a fence that he constructed some years ago. What might he do? And I was looking to see what review rights they have in relation to the trees. And the thing that I found interesting was that in 2016, Burra introduced a local law in relation to trees. In 2018, they announced a review, and that's still on their website. There's no indication as there's been a successful outcome of the review. But, some of us don't maintain web pages as well as we otherwise might. But the interesting thing is that the only review on a breach of the local law is to the chief executive.
Oh, really?
So it's an entirely internal system. And yes, we could send them to VCAT, but I think we'd probably double their workload.
Do we care about that?
Absolutely, absolutely.
It slows the rest of
Justice
us down.
denied.
Yes, indeed. Okay, if you've got a question for David, here we go, 1300 222 774. We will start with Daniel in Seaford this morning. Hello, Daniel.
Oh, hi, Virginia. How you going? Hi,
Good, thanks.
David.
Hi.
I've never rang before, so I'm a bit nervous, but
You're
anyway,
all right. You're just talking to me and David. No one else is listening.
Okay, I'll try and keep that in my mind. Look, out of the blue, I got a letter from the Department of Environment saying a caveat, of Environment, Land and Water, saying a caveat to be put on my house.
Yes.
Just out of the blue. And I've since, it mentions a law firm and another person. I've since found out that someone has filled out a credit application form and put me down as a guarantor. It's a family member, so it's a little bit sensitive. I got the law firm to send me the copy of the credit application that I supposedly signed.
Yes.
It's not my signature, it's similar.
Daniel,
Sorry?
if you don't tell them, then you are tacitly approving what's happened.
If I don't tell them that it's not my signature.
That you did not sign the application, that it is not your signature. Now, you get this interesting question. You'll create a problem for whoever it is who applied for credit.
Yep.
So you've got a couple of ways you can deal with it. If it's a family matter that concerns you greatly, then the answer might be you should talk to that person about how the debt could be immediately repaid, and at which stage the caveat could go away.
The person has done a runner. They've not contactable. They've just left the state. They were in a payment plan with the actual company, and the actual company just said they couldn't raise them. They paid off a little bit and then just disappeared.
Then, Daniel, what you need to do is write to them and say, not my signature. I did not sign the credit application. I did not agree to be a guarantor. Please remove your caveat.
Well, I rang the Victorian Law Institute and they recommended a lawyer, which I'm old and I don't have any money, but I got them to send a letter saying the signature was wrong. They sent copies of my driver's licence signature. They also mentioned that the address next to my signature on the form was actually incorrect. It had the wrong house number. There was a lot of discrepancies in the form. They never contacted me, and the law firm wrote back and said, no, we've looked at the signatures and we reckon they're similar, which they are similar. And if you want to remove, you've got to employ a handwriting expert, and that'll cost you, well, they did say $20,000.
No, a handwriting expert will cost you far less than that, Daniel. But
is it
a handwriting expert will want to look at original documents, not a scan that came from the lawyer. My problem is the amount of money it will cost you to make an application to the Supreme Court for removal of a caveat.
Yes, yeah. Well, it's not a great deal of money. I'm amazed they've gone to that. I sent a text to the family member saying, look, I'm disgusted, I'm upset, I'm a heap of emotions. Can you please remove it? That's all I wanted. And there's been no action. They can't
remove it unless the company that provided the credit won't remove it unless they can be satisfied that it wasn't you, or they can't be satisfied that it was... they need to be satisfied that you didn't sign the document. Now, do you know who the witness to your signature was?
Yeah, well, this person has since married a woman.
So you might need to go and talk to that person, but otherwise prepare every piece of document you can to establish that you didn't sign the document, and then just simply park it, Daniel. And then park it, because I don't want you to spend money either in a court proceeding to have the caveat removed.
Daniel, we'll have to leave it there just because there's lots of people waiting. Good luck. Thanks for calling in today. Sonia has called in from Cabo Nona. Hi, Sonia.
Hello, how are you, Doc?
Good, thanks.
Thank you so much for taking our call today.
Go ahead, what's the question?
But we are seeking an advice. My husband's business partner changed the locks of the business overnight. And he took over the business and started trading with a different name other than their company name.
Yes.
Which now today is the 8th day. From last Tuesday, we've been keep contacting him, keep asking him, sending him emails. He's not responding back at all.
Sonia, is it a company or a partnership?
Now, don't mention names here, Sonia. I don't want company names mentioned, okay?
Yeah, for sure.
So you're operating through a company or operating as a partnership?
No, it's operating through a company.
And is the company trading profitably?
No, he changed the company name.
No, it was the company that was trading last week before it was trading profitably?
Yes, please. Yes, please. The company
and in whose name is the lease? Is it in the name of your company?
No, the lease name was under the other business partner's name.
Then he's the person who's entitled to occupation of the premises. Sonia, I would be going to seek a lawyer for damages for the basically appropriation of the company's assets and giving up his role as a company director. So inappropriate use of assets and information.
Good luck.
But the lease is in that person's name, so that's the person who has the right to the premises.
But we paid him the bond money. We have evidence that we paid him the bond money.
I understand that, but this doesn't appear to be a formal sublease. So the company of which your husband is a member doesn't appear to have a right to occupy the premises. So you need to get all of your paperwork in a row and then decide what you want to do.
All right. Okay.
Thanks,
you.
Sonia.
Thank you, David. Thank you so much.
Good luck for that. Rob's called in from Ivanhoe. Good morning.
Good morning, Virginia and David. Yes, we are part of an owners' corporation, and we have a problem with one of the owners in regard to the owners' corporation fees. The owner lived in the property for a short time, but hasn't lived there for a long time, many years, and the property has been empty all of that time. Now, initially he did pay his fees, but in more recent times it's been very difficult to get the money from him. I've actually come across him several times in the street, and when he's reminded, he pays up immediately. There is absolutely no problem. The difficulty is getting a phone number from him for contact or an address. We haven't heard from him for quite a long time now.
When you say quite a long time, are we talking about months or years?
Oh, years.
And what's the level of your owner's corporation fees?
Oh, it's only about probably $1,500 a year, I suppose, each.
So and so that adds to how much money?
Well, we're dividing it up, so we pay an extra few $100s each.
No, how much does the person who isn't paying owe you?
Well, at the moment, he's just 1 year behind, I think.
So he's only $1,500 behind?
At this stage, yes.
Yeah, Rob, ultimately you have the right under the rules to charge interest if you resolve at an annual general meeting to charge interest on overdue fees. You also have the right to take him to the Magistrates Court or to VCAT to get a judgment against him. And you would ultimately have the right to have the units sold up for non-payment of the fees. But your difficulty is going to be that the owner's corporation's going to get a bill for legal fees, not all of which will be recoverable from the person who won't pay.
And are those fees likely to be significant?
Well, it depends how far you go. Magistrates Court, probably not, assuming that he doesn't take any action in the proceeding. But if you ran it all the way to the Supreme Court with an order for possession and an order for sale, you could be at $10,000.
See, the difficulty is he's quite happy to pay. There's absolutely no problem. It's just that he has to be reminded, and we don't know where he is. Therefore, we want to.
Is the property managed? No, the property's not managed by anybody, is it?
Well, we do have an owner's corporation manager.
No. I mean, you told me that his unit is empty, so there's no rental agent managing the property for him.
Oh, no. In fact, his services have been cut off and so on. So it's completely vacant.
If you see him in the street, why not follow him to see where he goes?
We haven't seen him for a long time.
All right. Then I think...
So what now? Well, how do we resolve this? David?
Have you done a title search on the property?
No.
So if you do a title search on the property, that will be the address he lived at when he bought the property.
Okay, and how do we do that?
You can visit Land Use Victoria, luv.vic.gov.au, and you can do a title search.
Okay.
You can do a title search for the unit, and that will disclose his residential address at the time he bought.
Good luck.
He may well be still there.
Good luck with finding him. Thanks for calling. Rob in Kremen has a stormwater issue. Hi, Rob.
Good morning. I've got an issue with the council. I've got a legal point of discharge for my stormwater, but
Rob, pick up the phone and speak clearly, will you?
Are you there? Or
Rob, are you there? All right.
Hello?
Rob, are you there? Last chance.
Sorry, Bluetooth. You there?
Okay.
Yes.
Now state your problem succinctly for me.
Rightio. So on my block of land, I have a legal point of discharge, which is in the rear of my property. I've got an established property, so the house was built when I purchased it. Basically, in that easement, there's no asset, there's no drain. So I've contacted the council, and basically I'm not really getting anywhere with them. They've done a costing, and they've said it's a lot of money, and they don't have the money to fix the drain. But my water currently goes into an aged care facility, so I'm just worried, can I get in trouble for my water going into their property?
Quite possibly, Rob. I must say, I've actually got a similar issue for a client which would answer your question. And my question is the bit that I am still working on is that at what point does stormwater become responsibility of either the water company or the council? And I don't yet know the answer to that question. So
the council actually know. The council have admitted that it's their issue.
Because they presumably gave the previous owner a permit.
I believe so,
allowing for a discharge of the water that now goes into an aged care facility that presumably did not exist at the time.
That's correct, yeah. So I've also got a fella down the road that lived there before the aged care was built.
Yes. And
they were aware of the issue then. So it's sort of raised its head twice, and now with these big rains, my property was flooding. So
Rob, let's see if I can give you a better answer next week, because I'm trying to look at it for two other people at the same time.
Okay.
Who has the responsibility for the stormwater and when? So listen next week.
Okay, thank you very much.
Good on you, Rob. We'll try and have an answer for you then. Peter's in Moonee Ponds. Hello.
Hi, how are you? Look, sorry to trouble you. I'm a bit nervous as a long-time listener, first-time caller.
Well, great to have you on board. Good morning.
Thank you. Very quickly, I've got a mother that has a mental illness and she's living in a home. And I've often said to her, well, Mum, do you have a will? Do you have any sort of, well, what do I do? I mean, there's two of us here. And she's just refusing to answer. Just refusing to admit whether she has or hasn't got a will. So, she's at a stage.
So how old's your mum, Peter? She's no longer
80s.
Capable?
No, she's housebound and, she's...
And living in care?
Schizophrenia.
Right.
No, she's living in her own home, but we're bringing her food, as in my sister and me.
Yes. So what precisely is the question?
The question is, how can I find out a will if she's not telling me she's got a will?
You would in the similar situation, I would contact all the local lawyers.
Yep.
And give them your mother's name and ask them they're holding a will for
really?
her.
Will they answer you, though? Are they obliged to tell you if you ask that question?
It depends on the question that you ask. Normally you'd come along and say, it depends. Mum won't tell me, won't get you an answer, but my mum's gone into care, she's not able to respond, I'm just planning for the future. The aged care facility want to know whether she's got a will or not. You'll probably you won't get told what's in it, but you'll get told that they do have a document.
Okay.
If there is no will, you might also look, if she's living in her own home, you might look and see, and she lived in your home with your dad? With the home?
Yes, she did.
And you
my
might
father since passed away. Yep, go.
You might find who looked after your dad's estate, and you might also look back to the time she bought the property. And they
bought. That's a very good point. But they bought the property in 1975.
That's okay. Council will still have records.
Okay.
So,
and
back in 1975, the name of the lawyer who prepared the transfer of land appeared on the transfer. So you can go back and say, well, so-and-so acted for them in 1975. And you find out...
Okay. Let's just cut to the chase.
Now, in the event that she has no will...
Yes.
Then the estate under the intestacy rules is divided equally between the two of you. If you have a sibling who's died leaving children, then a third would go to those children. So basically, if there's two children, no other siblings either have died, then it's divided equally between the two of you, and the two of you have the right to administer the estate.
Appreciate your time. Thank you very much. I appreciate you being very helpful. Thank you.
No worries. Thanks for calling in. Hope your mum goes okay too.
Thank you.
Maria has called in from Chadstone. Hi, Maria.
Hi. I have a owners corporation question as well. What is the procedure for unpaid fees? It's gone to VCAT and we still don't have any money or any...
So the Owners Corporation has taken an owner to VCAT for an order for the payment of fees.
And nothing has happened, and it's just, multiplying in money. And I just want to know whether we can put a caveat. Can a Owners Corporation put a caveat on the property?
The Owners Corporation already has a charge on the land by operation of law. A caveat would achieve nothing. If I was to buy that person's unit, I'm now responsible for the Owners Corporation charges. So you will get it sooner or later.
Okay.
So
right.
I wouldn't spend the money on the caveat because I believe the Owners Corporation Act gives you that interest in the land anyway. If you were listening before to Rob, you could, if you really wanted to, you could register the judgment or the order at VCAT in the Supreme Court and you could sell the unit. But we're spending a great deal of money for not a great return.
Okay. The problem is we're all sort of propping up with all the expenses, which is going to lead me to have to sell my unit because I can't keep up with the fees and all the added expenses that go along with it.
Right, then you'll need to persuade the Owners Corporation to execute against some... So how much are we talking about, Maria?
It's over... it's nearly $20,000.
Ouch.
Yeah.
Do you know where this person lives? Do you know if he has... You don't know anything...
Well,
you must know something to get a judgment.
Yeah. I don't personally, but what what would we do with that?
You could transfer the judgment to the magistrates court, and you could then ask the sheriff to go and seize a person's assets to sell something to recover the $20,000.
All right. So it has to go to the magistrates court.
The magistrates court, the VCAT doesn't have an enforcement process.
Yeah.
If you want to use an enforcement process, you would either take it to the magistrates court or the Supreme Court, depending upon how you wanted to do the enforcing.
Okay.
Okay.
All right.
All right. Thank you so much.
Thanks for calling in. Let's hear from Bill in Essendon. Where are you, Bill? There you are. Good morning.
Yeah, good morning to you both.
Morning.
David, I might have a bit of a problem or a pending problem with a warranty issue on a brand new car. Just a bit of a quick chronology rundown. I took delivery of this new car end of January and did the 1 month follow-up for its first service.
Yes.
I then let them know that there was a bit of a cough or a misfire that I thought was happening. They couldn't replicate the problem. So we agreed that we'd keep an eye on it. So we did, and 2 weeks ago I took it back with an official request to look at it properly. Took an engineer for a test drive, and he acknowledged that yes, he could feel the cough or the misfire.
Yes.
So I picked the car up after it had been looked at, and got a report back that couldn't replicate the problem again. But we've been in touch with the National Service team, and that's just consistent for the car, and nothing more can be done. And if you have any further issues, here's an email address for the head office of the supplier.
Yes.
To voice your complaint, which I did. And again, 3 or 4 days later, I heard back from them to say, this is consistent with the make and the model.
What?
Yeah, consistent with the make and the model.
Yes.
And we've got another car that does the same thing. And the National Service team say that it's all okay, no issues. I just replied to them to say, hey, listen, if Rolls-Royce or General Electric told that to the Boeing or Airbus, I think you'd have a bit of a problem.
That's true, but you didn't pay for a Rolls-Royce or a General Electric jet engine. Yeah.
But David, $50,000 for a car is a fair chunk of change.
Absolutely. The question is really whether or not, if they tell you it has no effect on the drivability or anything else.
In writing.
No, they've already told you that. I understand that. So the question would then be, I don't really know. I suppose the question, you would need to basically say it's fixable, but you won't fix it.
Right.
And they're presumably saying that it's either not fixable or it's not worth fixing.
Well,
sounds like not worth fixing is their approach.
Yeah, well, if you go back and listen to John Fain and one of his old expressions of the WWW, the symptoms of this complaint is all over the internet, consistent with this supplier and the model of the car.
Oh, so you didn't do enough research before you bought? Is that what you're saying, Rob?
Give me a smack. Give me a smack.
Okay. Yeah. I understand.
Is that the end of the discussion then?
Then what you need to do is just agitate as much as you possibly can.
Yeah, make yourself an annoyance.
Yeah.
Just be
Park
the
outside
person,
the dealership.
Exactly. Mm-hmm. Be the person who is so annoying that it's simply easier to either fix or just to come to some arrangement.
Or make the problem go away.
Make the problem go away with another 1 month old car perhaps that doesn't cough. Oh, I'd hate that though. Is it annoying to drive?
It's just... no, there's no bang, clunk or anything like that. Yeah. And apart from that, I love the car. It's just fantastic to drive.
But you don't want anything to sour that unbridled joy of a new car,
18 weeks old. And,
no, that would really
7,000 kilometres. Yeah. All right.
David's enjoying himself listening to us.
No,
I'll be the perennial burr under the saddle.
On my side, Virginia, I'm deaf in the left ear.
Right.
So when we're driving along, there's a noise in the fan in the car that we drive that drives my wife to distraction, and I can't hear it.
I thought you were going to say that when you drive along because you're deaf in the left ear, then there's a noise on your left, which is your passenger, but you can't really hear them, so it's not
I
much
make
of a
a
problem.
special effort to pay attention, Virginia.
Don't go making those jokes here. David, you got a little bit of homework. Nice to see you. Thanks for coming in. And great to have all of those calls. Sorry we couldn't get to all of them. Sorry if I sounded like I was chivvying people along. Let me explain my thinking. There are so many people calling in and on text. I'm trying to get through as many as I possibly can in half an hour with David Whiting. It's all to make sure that we can get as many of you to David as possible. And if I scoot you along, it's only to that end. But I certainly don't want to sound rough. Or actually, maybe I do want to sound rough. Who knows? From time to time.